Now, let's bring you this one about the Western Cape Judge President John Hlophe, who's set to appeal a court ruling relating to his legal battle against the Judicial Service Commission. Hlophe wanted the matter referred back to the Commission so that it can conduct its own investigation into allegations of misconduct rather than vote on his impeachment. The High Court on Thursday dismissed Hlophe's review application, which sought to have the JSC's gross misconduct findings against him set aside. We're joined now by Barnabas Xulu. He's the lawyer for the Judge President Hlophe, to give us some more insight on this. Mr. Xulu, good afternoon. Thank you very much for your time. Can we just get straight to the matter? Why does your client want to take this matter on appeal? What are the main reasons?
Good afternoon, Dan, and good afternoon to the listeners. Look, the main reasons have been articulated in summary in our statement, which was issued on Friday, where we've made it clear that our instructions are to seek leave to appeal before the full bench that have made its judgment on Thursday. The reasons are we have seen a new trend by this court where the interpretation of the Constitution has received new meaning, which is leading to the subversion of the very same Constitution. What do I mean by that is that our courts have interpreted the section 178 of the Constitution, and they're very clear how that section needs to be interpreted. It is using a clear meaning, which is saying who is supposed to be participating in the JSC dealing with the disciplinary matters of the judicial officers. It's the Chief Justice or the Deputy Chief Justice, the President of the Supreme Court of Appeal, or Deputy. It does not leave room for any other person to replace that kind of leadership in the judiciary. That's how the Constitution made it very clear. Now, this judgment has come up with a new meaning of saying, in the event either of the officers that I've mentioned designated to deal with this matter are not available, there can be reasonable and adequate justification to depart from or insisting that the composition must consist of those officers. So we're saying, this is to depart from the already interpreted, was in the case of Helen Zille, which was before the SCA, the highest court, then the High Court, is binding on the lower court, which is the Gauteng High Court. They should have followed that, because it means that because the JSC was not properly consulted, the decision, therefore, is not going to be binding to anyone until such time it is properly consulted. So basically, the ground is that the Judicial Service Commission that considered the tribunal ruling was not properly consulted.
This matter has been going on for quite a long time now, toing and froing. I don't know, maybe it's about more than 10 years, if I may say so. It's been sort of pending for quite some time. Don't you think, say, it will be in the interest of justice and the rule of law that your client allows the impeachment process to proceed at the JSE, so that his case can be heard and then it can be wrapped up and it's all done and dusted?
It's a constitutional matter. Look, it's a constitutional matter in this regard. Let me make an example. We have the president in this country. He, in terms of the Constitution, has got 2 terms to serve. Even if you have the whole of South Africa marching, toying, saying that he must take the 3rd term, that will never happen unless, or it should not be in the interest of justice, and it should not be constitutional unless the Constitution is amended to that effect. Now, this is the same thing. Here you have got a body that was not properly constituted. When the language of the Constitution is very clear, instead, a makeshift was made just to proceed with the matter instead of following the Constitution as it was stating. So you cannot, as and when, twist around the Constitution because you want it to meet your wishes. So it's a very important matter. Let's have it done properly so that justice is served and the rule of law is observed.
So finally, say, what's the next step now? Your client has instructed you to appeal this latest court ruling. What will be the next steps now?
Well, the next step is to file the notice. I'm in chambers as we speak, consulting with counsel, with the legal team. In fact, we are preparing the leave to appeal, which will be served shortly with all the parties that are involved, whereby this challenge is made clearly. We need the direction from the highest court that the principle of stare decisis, which says precedents are binding on lower court, has been clearly subverted in this judgment. So it is important for clarity and for the confidence into this judiciary that when the law states that this is how the procedures should be followed, it must be followed in that way. Here, what is clear is that the judges of this bench has basically conflicted what is the procedure, where the Judicial Service Commission can come up with their procedure, which is within the means and be practical. And the composition, you can't compromise the composition because that will mean you are now amending, you are making the court to amend the Constitution. They are not legislators. So that is where the unconstitutionality comes in.
Thank you very much for clarification. We'll have to then watch and see when you are going to be filing those leave to appeal application papers soon. Thank you very much. Barnabas Xulu, John Hlophe's lawyer.